Let's begin our broadcast today with business and immigration law updates. This is a presentation of the Khurana law firm, where the chief attorney and counselor at immigration law is attorney Ramesh Khurana. This law firm has been providing services to our community for many, many years. Today, attorney Khurana is going to talk to us about 5 harmful blunders to avoid relating to immigration. The moderator with him here today is attorney Kenneth Haber, who is also a licensed and practicing attorney in the state of Maryland. Let's hear these 2 attorneys in their legal dialogue.
Welcome. This is the Capitol Forum. With us today is Ramesh Khurana, a well-known Maryland immigration attorney who represents people across the country and across the world. And he's here to discuss with us 5 common harmful blunders to avoid that relate to immigration, so that people will be able to avoid them. Welcome, Ramesh.
Thank you so much, Ken. I appreciate it.
As far as these 5 blunders, what are the consequences of not changing your address with the immigration authorities at Homeland Security? I take it that is probably one of the main blunders of the 5.
Yes, this is a major blunder. If you have filed any petition or application for an immigration benefit with the USCIS, and if your address changes, please be aware that you have to notify the USCIS about the change of address within 10 calendar days. Otherwise also, this is a violation of immigration laws if you don't change your address within 10 days. And as I said, if you applied for some immigration benefits, some notification comes from USCIS and you don't receive it, then the immigration benefit will be denied. USCIS going to come back and tell you, listen, you didn't change the address, you didn't meet the requirement of the regulation, so you have missed the bus. Sorry, we can't help you.
Does this apply even if you have an immigration attorney who is representing you and he would get the copies of the paper? You still have to keep them posted of your address?
That's a very good question. If you are represented by an attorney, then hopefully the notification comes to the attorney as well. Then of course attorney receives your mail and attorney knows what's going on, but nevertheless you are still required to change your address within 10 calendar days.
That's interesting. So
yes,
everybody should know that even though that they have an attorney, they still need to change the address with the immigration authorities in order to be in compliance with the regulations.
Yes, this will be a major blunder if you don't change your address within 10 calendar days. These are not 10 business days. Remember, these are 10 calendar days. Very simple process. Go on the website of uscis.gov and keep your petition which is pending in front of you, and it will take you hardly 5 minutes to change the address online.
Another possible blunder, and that is making a little white lie, as we call it in this country, where we don't think it's so serious. It's a little white lie. It's not a big lie. Is that a blunder, immigration blunder?
You are a criminal attorney and nobody knows better than you do. Having worked as an assistant U.S. attorney, Ken, don't misrepresent ever. Don't misrepresent ever. If you misrepresent, I think you are out of luck.
You can actually lose whatever entitlements you were entitled to because of that.
Yes. There may be certain situations where probably you may be entitled for a waiver, very limited situations, but why to run that risk? Immigration department knows everything about you. Don't try to oversmart them.
They're sort of like big brother, is that it?
Yes, they know everything before you go there. So before the petition is filed. So better be truthful, be upfront, disclose everything. If you have hired an immigration attorney, disclose everything to the immigration attorney, and I'm pretty sure immigration attorney, whatever knows, whatever is to immigration attorney's knowledge and notice, he is going to guide you that you have got to disclose this information.
That's good advice. What are some of the harmful effects of the blunder of overstaying your visa?
Blunder of overstaying your visa. If you are coming here on B1, B2 or tourist visa and you have been allowed to stay here for a period of 6 months, so you cannot overstay it. If for some reasons, let us say that you are here for some medical treatment and you need to extend your stay in the United States because of the advice of your attending physician, yes, you can apply for extension. Apply for extension well in time, because approval of this kind of extension request may take about 8 to 12 weeks. Don't apply on the last day. So otherwise you are committing a blunder of overstaying your visa. If you overstay your B1, B2 visa, then your B1, B2 visa is supposed to be withdrawn. It's no longer valid, and you will have a bad experience when you return next time at the airport. They are going to ask you hard questions and probably you will be sent back under the expedited removal, or you will be denied admission to the country.
Are there any adverse consequences of the blunder of not hiring a competent immigration attorney?
As such, if you are not hiring a competent immigration attorney, I don't think you need to hire an immigration attorney for each and every application or petition. But if you really want to take the help where you think that you are not up to it, you can't handle it, better take the help of immigration lawyer, because sometimes there are very simple questions and you think you can answer them, but unknowingly you answer those questions in such a way that those are treated as misrepresentations. Not that you wanted to do it, but you did not understand the question very well. So I think it's always a good idea to talk to an immigration attorney, or at least seek a consultation with an immigration attorney if you have certain doubts, if you are trying to do it by yourself. Otherwise, take the help of a competent immigration lawyer. Why I am using the term competent immigration lawyer, that there may be certain people like notarios who would say that we are lawyers. They are not lawyers, and sometime an attorney may not have an experience in the immigration field. The person is just doing the general practice or is new to the practice, then certain mistakes might be committed. So always get in touch with a competent immigration lawyer if you have to.
You know, it's like I don't do my own taxes. I have a CPA who does my taxes, because that's a whole different world of law, the tax law. And I wouldn't venture into it any more than I would venture into immigration unless I had you telling me what to do.
Same way can I do. I don't do everything of mine for which I have not been trained. I always hire professionals to do my taxes and such other jobs.
Why should and this is another blunder, if an applicant does not keep a copy of his complete filing record, what are some of the consequences, and why should he keep a copy?
Ken, this is really one of the worst blunders a person can commit. If you are filing an application or petition with the USCIS, make sure you have a complete copy of the package which you are filing with the USCIS. Let us say after you have filed and on the first scrutiny you receive a request for further evidence from USCIS, and they are challenging some of your statements which you made in your applications or petition. If you do not have a copy of the package, how you can be sure whether the question being asked is really in the way you have understood? And sometimes they question your documents. If you don't have copies of those documents, definitely you are going to be in trouble. So make sure before you mail out the package to USCIS, you have a complete copy of the package as part of your record. and always keep your immigration records with you. You never know when you might need them.
What difficulty would a person have to get a copy of it from the immigration officials? Certainly there's the Freedom of Information Act.
Yes, there is a Freedom of Information Act, and you can apply to obtain copies of your immigration application which you have filed under this act, but there is a long queue. When you apply for copies under the Freedom of Information Act, I have seen cases where it takes more than a year, sometimes even 2 years. And your petition is to be adjudicated now. You need to respond to some of the questions regarding further evidence, maybe within 30 days. How will you respond to those questions? Definitely your application or petition is going to be in trouble.
Yes. I've had situations with Medicare where I filed Freedom of Information Act request to obtain information, and by the time they get around to calling up to see if we still want the documentation, the case is over.
There you go. So same applies to most of the federal agencies. So always make sure that you have copies of all the records.
I think that's very, very good advice. Can you please explain a little bit more in terms of some of the adverse implications if an individual is caught not accurately answering the questions that are posed to him?
Yeah, sure. The problem is if you are not answering the questions correctly. Now, how they are going to verify the veracity of your answers to the questions? Because the officers at the port of entries or even at the service centers, now they have access to large amount of databases. So they can access your statements which were made at the US consulates abroad when you applied for some immigration benefits. Plus, even if you are a US citizen, you have gone through the immigration process. First, maybe you are a green card holder or you are holding a non-immigrant visa like H1L1, and then you obtain your green card, then you obtain your citizenship. Every time you fill up certain application forms and you provide certain documentation, make sure your statements are consistent. Sometime unknowingly, you do not look at your records and you commit some mistakes, and those dates, particular dates which you are mentioning or some documentation which you are giving, those are of material benefit, and you may be charged of misrepresentation. And I have seen people being put in removal proceedings because of misrepresentation. So be careful. I think cameraman is indicating to us we have got to wrap up.
It seems that way.
Time is over. So in the end, I would just like to say, Ken, thank you very much for inviting me. It is always a great pleasure spending time with you at the Capital Forum. And I would like to advise the audience, whenever you have some immigration issues, always talk to a competent immigration lawyer so that you don't get stuck in the complex world of immigration. Thank you very much for being with us.
And thank you for joining us on the Capital Forum.
Thank you, Ken.